This conference will
Great. I think we should probably wait a few more minutes for people to arrive.
Kevin, do you think we should probably go ahead and get started?
Sure, let's go ahead and get started. Can everyone hear me all right? Good, good. I'm going to call the roll real quick, and if you could unmute and just say present so that we know your volume is working, that would be great. So, Kent Barnett.
Okay, I'm here. Sorry, I was having trouble.
No worries. Jack Bierman.
Present.
Michael Cole.
Present.
Anika Cooper.
Here.
David Engstrom.
I'm here.
Great. Claire Evans.
Present.
Susan Grunman.
I'm here.
Janice Hoffman.
I'm here, thank you.
Jeff Lubbers.
Here.
Alexander Manuel.
Here.
David Pang.
Here.
Great. Roxanne Rothschild.
Here.
Christopher Walker.
I'm here.
Russell Wheeler.
I'm here.
Is there anybody else on the committee whose names I have not called? Great. And also from ACUS, but not of the committee, William Funk.
I'm here.
And Joe Solomey. Okay, so Joe's not with us yet. Great. So Nadine.
Thanks, Gavin. I don't want to take up too much time so that we have time to discuss Chris and Matt's report and then get down into the recommendations. We will deal with preamble at our next meeting. So today will be recommendations, and I'm hopeful we can get through them. Before I turn things over to Chris and Matt, I am required to cover the ground rules, which I think is always a good thing to keep us all on the same page. So let's start with ACUS members who have full speaking privileges, and you have the ability to unmute yourself. So I'd ask you to stay on mute, and if you want to speak, either raise your hand or you can add a comment in the chat feature, and I will have you, acknowledge you and have you speak, and then remute yourself when you're done. We've done these. Hopefully, all of us have done these several times. It's better to be on mute for everybody's sake. So please use your webcam. It's helpful so that I can see you and all of us can see you. I find that it helps the process since we can't be together in person. In terms of priority of speaking, ACUS members have priority over our invited guests. Members of the public, I ask you to also use the chat function if you want to speak, and I will acknowledge you and turn to you at an appropriate time once our ACUS members have had, our committee members have had an opportunity to speak. Chat function, please use the chat function only to indicate when you'd like to speak. We do not want to have any sidebar discussions or substantive comments in the chat feature. Let's have them open forum amongst the group and not in the chat. This is obviously recorded. The chat comments are not captured. So let's use that solely for when you want to speak. And when we get to voting, which hopefully we'll get to do maybe just on the recommendations today, and then we can do the preamble at the next meeting, only members of the committee have a vote, and we will cover that ground when the time comes. One additional note that I want to add before we turn things to Matt and Chris is that this project is slightly different from others we've taken up as a committee. ACUS Vice Chair Matt Weiner will not be participating in any capacity other than as co-project consultant. And so we as a committee have the good fortune to look to several people, Reeve Bull, Research Director for ACUS, General Counsel Sean McGibbon, and then our staff counsel Gavin Young for any assistance we may need on substance and procedure. Likewise, Professor Walker is a committee member, but he will be recused from voting on this project since he will be here in his capacity as the other co-project consultant with Matt. So with that, I will turn it over to Matt and Chris. I'm not sure which one of you has decided to speak first, but as co-consultants, I'm sure you can work that out. We want to hear from both. Thanks.
Well, I will turn to Chris to speak first since he's getting paid for this and I'm not. But I just wanted to say one more thing on the recusal front, which is that I will not, at the plenary session, I will not be presiding over the deliberation, the debates on this recommendation. It will be another member of the council, most likely Ron Cass, but that hasn't yet been finalized. So I turn it over to Chris.
Great. Well, you've all seen the report, so I'm not going to spend too much time on this. But Matt and I have been working for a little over 2 years now on this project of looking at agency appellate systems. And as part of that, we spent a lot of time at the get-go just trying to collect all publicly available sources about the 12 agency appellate systems that we looked at. And I'm guessing none of you ventured over to the website to see the 350-page draft appendices on that. But that really helped us to get a good sense of at least what on the books these agency appellate systems look like. And then after that, Matt and I spent time interviewing at least one, if not 2 or 3 or 4 people that are high up in these different appellate systems to get a better sense of how they work, of what challenges they have, what objectives they're supposed to serve. These were semi-structured interviews, so we had created an outline that we vetted and explored in advance through some exploratory interviews to make sure that we were asking the right questions And then we largely stuck to the outline, although we also had a fair amount of follow-up questions. They came up from either the case overviews that we had created in advance or just from the conversation and some of the points that they flagged. And so it's been a tremendously interesting and I think, project to work on and to hear from the folks that run these appellate systems about some of their challenges, some of their best practices. Like some ACUS recommendations, we didn't do this project because there was a problem we were trying to solve and provide a recommendation to solve it. We did this project because there hadn't been a good trans-substantive exploration of this area of administrative law. And we wanted to get a better sense of, are there common challenges? Are there best practices that some agencies have adopted that would work well at other agencies? And so you'll see that a lot of our, the report, the findings, but I think even more importantly, the recommendations really try to get at some best practices. And one thing that guided us, I guess two things I'll say that guided us, and I'll end on this. One of the kind of main takeaways that we got from the interviews and the case overviews is that a lot of these agencies haven't actually crystallized or formalized why they're doing this. What are the objectives of this? Is it efficiency? Is it error correction? Is it policy making? Is it interdecisional consistency? Is it quality assurance? I mean, there are a number of different objectives that they could be trying to proceed. In the interviews, most of them had a pretty good sense of what they were doing, why they were doing it, but they've never actually put it down in writing. And I think that's one of the issues that at least, actually I say I'll speak for both me, Matt and I, that really kind of stuck out to us, is that it seems somewhat odd to structure a whole agency appellate system without kind of figuring out why you have it in the first place. And then the second observation that I would make is not all appellate systems can or should have the same objectives. They exist for different reasons. And so our recommendations really shouldn't be read, and to the extent that they are, we'd love to correct that, as trying to prescribe some sort of one size fits all, appellate system or best practices. They really well vary depending on what the purpose of that appellate system is. And so I think I'll just stop there. And I guess, Matt, you can tell me what I messed up or what I should have said, since we, any event, I'll turn it over to Matt.
Oh, that's great, Chris. I have nothing to correct. I have just two follow-on comments. The first is, and this is apropos of what Chris said, we did approach this with some degree of modesty and took very seriously the idea that trans-substantive procedural reform is very difficult, if not entirely misguided in this particular context, whatever sort of its merits in the federal court system. And then the second thing I would add is that we've heard from a few people with comments, but we would very much welcome, quite apart from the recommendations, but we would very much welcome after this meeting comments that any committee members would like to provide to help us with the revision we plan on undertaking during the next 2 weeks or so. And that could be suggestion that could be matters large and small, pointing out errors, suggesting additional, not too much, but additional research we might undertake that would be manageable. Materials, especially from the agency folks on the phone, materials on their websites that we may have missed, or even if we didn't miss it because we didn't study that agency, that we ought to take a look at when we undertake our rewrite. So I have nothing further beyond that.
Great. Thanks, Matt. Thanks, Chris. Before we get into the recommendations, I thought it might be helpful to just take a little bit of time if there were any comments, questions, points to discuss on the report. I found it quite comprehensive, and I realize that it's still a work in progress, but the work that you've put into it, I think Chris said 2 years now, it's evident. And so I open the floor in that sense. If there are committee members first who want to raise questions to ask the consultants, or just comments that will help maybe get us to the point where we'll take up the recommendations themselves. I'm looking for hands and I'm seeing none. Excellent. Russell, yeah.
Just very briefly, I sent this to Matt. I thought, just to echo what you said, I thought the report was stupendous. I found especially the introduction, this is such a chaotic field, and I thought the way it pulled together various strains, I just found it very educational. I need a lot of education in this area, but kudos to the authors. I really mean that.
That's great. Anyone else? Okay, well, let's dive into the recommendations then. That's easy. We're gonna get them up there. They are great, 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 great. So we'll just start with objectives, which I think is something Chris, highlighted in his comments, that this is something, the systems that they were looking at, perhaps new, I guess, hopefully they know internally. It's just something they've not really maybe documented or put down on paper. If it's not clear from the system, the way it's structured, or the statutory mandate that they may have. So we'll just start with section A. We can start with the first one. Are there comments, questions, language? I see Kent. So let's go, Kent.
Okay, thanks. Just two things on this. One very minor. I would put the second part of that first sentence into active voice, just saying agencies identify what objectives their appellate systems serve, instead of passive voice with it, keep it more active. And then the second part is, it was a little unclear to me because I read the recommendation before I read the report, exactly what they were talking about with objectives, and it could be that that's going to be clarified once the preamble is done, but I would consider just adding a little language to make it clear to the agencies what we mean by objectives. And of course, they're talking about the policy making or the error correcting functions or something along those lines.
Any thoughts on that suggestion?
I would just say we should definitely include that in the preamble, a summary of the potential objectives. Not entirely sure I'd want to include it in the recommendation, but definitely in the preamble at least. The preamble to the recommendation.
No, I think that makes sense. Do you want to, Gavin, do you want to go ahead and however you prefer to do it, you could, I think the active voice one is easy enough to change now.
Okay.
So it was what objective or objectives their appellate systems serve? Was that it, Kent?
Yes.
There we go. Okay. And then, I think the clarifying language will be in the preamble. That's to come. So that's great. Okay. Yeah, I mean, obviously the objectives could vary, and we can have examples in the preamble. There may be others. Different agencies may have different thoughts on that. I know what our objectives are at our agency. Okay. Anything more on the first one? We can move to the second one. Looking for hands. Great. Second one, the lines 9 and 10. Anything on that?
Yeah.
Yeah. Yes.
So this is reading number 2 in light of B. I think, when I read this, I thought that B, everything under B was sort of the heart of the recommendation. And I think it's really, terrific. But it seemed a little bit out of order because number 2 under the first thing is basically specifying something that ought to be included in the material that's supposed to come out with B. And I didn't really have a clear thought on how to deal with this, but maybe identify and publish in number 1 and then just eliminate number 2. And then in B, add something that, the objectives should be included in the material that we're asking to publish under B. And then I have a comment about B1, but I'll leave this for now. I don't know what the people in charge of this think. I mean, I'm like astounded at how good this whole thing is and how comprehensive it is. But this is it's a little, just a formal tweak.
I think that's a great idea. And echo, so you're saying say identify and publish in line 6, and then you could echo that in B when we get to B.
And B, say that that's one of the things that ought to be included in the procedural rules that they're publishing.
So you would strike lines what are now.
Strike 2. Yeah, right.
Any thoughts on that? Chris and Matt, did you have any reaction to that or no?
I won't. If I don't disagree, I don't have a reaction. If I don't say anything, I guess I agree would be maybe the cue.
That works. I mean, the concept's still there. It's just fewer words, which is always a good thing.
I mean, I wouldn't be unhappy with publicly announced if the authors were sort of, enamored of the idea of an announcement, which is more dramatic than just publishing it, but
like a scroll. Yeah. No, I think this is
perfect. Yeah.
Okay, great.
Just one thing, sorry. If I want to talk, I put it in a chat, or can I just talk?
You can just talk.
Okay. Not to be contrary, but I kind of liked the 2-part one before, or if we're going to put it in one, I think it would be nice if we made it clear what we mean by publish, because when I see publish, I think, what, in the Federal Register? But I like that number 2 makes it clear that we're publicly announcing in the rules themselves, whatever it is you're doing to make your procedural rules, you include in it a statement of what your objective or objectives are. So if there's some way we could make it clear in one that we're saying that we should identify and publicly announce or publish or whatever, but make it clear we're talking about the recommendation is that it be a part of the rules. And I think that makes a lot of sense. As opposed to just leaving me, I might be a little confused in saying, what do you mean publish and where? And maybe I'm just being a little defensive.
What if we said and publish in procedural regulations? What object?
Yeah. Yes, I like that.
Another way I could deal with this is add it as on the list in part B1, just to make it clear that that's one of the things they should consider.
Mm-hmm.
Well, let's leave that at 1 there now, and then we can echo it. In the list. Does that address, Roxanne? That works. Okay.
Nadine, I have one additional comment on 1.
Yes.
So I think one of the concerns that I have is, like, the report made pretty clear that the objectives need to be consistent with the standard of review. And I think that's a really important point to make. And I think it's worth sort of including either an A1 here or down in B, whatever it was, where we get to the standard of review. Because one concern I have is that if you have a standard of review that is something like clear error or, material error or something like that, but then your objective that you also publish is just, error correction, there might be some confusion among litigants as to what exactly they have to show on appeal. And I think, agencies want to make it clearer to people what they should actually be filing on review. And that's not to say that, your objective can't have a broader sort of look at things, but I do worry about confusion. And so I think if we included something like what was in the report itself, which was that that the objectives need to be consistent with the standard of review, or should be consistent with the standard of review.
Are you thinking that so that would be language? I think that would stay in this in one. I don't think we would.
Yeah, I think it's something that we could add to 1, or we could add to B. What I think it's the standard review is F, but I think it actually works better to include something like that in 1.
Okay.
Is that Anika? Who's speaking?
Yes, that's Anika.
Yeah, that's me.
I think Anika's point is actually outstanding, and it might be something for us, Chris and I, to consider on the redraft or for the next version. We have thought about agencies identifying their objectives in appellate programs for the benefit of the agency, and Anika's coming at it from the benefit of the litigant to some extent, just as, say, Supreme Court Rule 10 does, and that's a very important perspective that I hadn't probably given adequate thought to.
Anika, did you have specific language you wanted to propose, or we can leave that?
I think I didn't write it down exactly, but I think in the report itself there was something that said that the agencies should ensure that the objectives are consistent with the standard of review, or vice versa. So I think language like that would probably work.
Nadine, I was wondering, I really like the idea. I do wonder if it's worth moving from D5 up to 8 and make it A2.
Okay.
I wonder what committee members think, but just hearing the comment, it made me realize that maybe that's a better place for that recommendation.
Yes. Anika, does this language hit the point?
Yeah, that absolutely, that works for me.
Well, let's make that a separate one, right? Right.
Yeah, I think we could make it 2.
Yeah.
Can I chime in here on this? It
Sure.
seems to me that this section is it's a general section that covers everything. So it almost seems like really what we want to say here is agencies should establish procedural rules that are consistent with the agency's specific objective for their appellate assistant, and then maybe add something like, especially the scope and standard of review, because we're in a global section here about the way that, I would assume that the idea that all the procedures should be established in light of those objectives, that's the reason for foregrounding the objectives this way. Am I incorrect about that, or? It seems odd. I guess it's, coming in from the other side, it seems odd that in A, we're singling out the scope and standard of review, when it would seem like we would want the agencies to establish all of their procedural rules and practices, in light of those objectives.
No, I see your point. Jack, what did you think about the language that we had earlier before we pulled up the language from D5?
Well, actually, I guess my point is that We already say that in the first one, actually. We say they should design their process and draft their procedure regulations accordingly. Then, maybe especially, and this is especially important when agencies establish, set and establish the scope and standard of review. And then I don't know, and then we're bringing up about de novo review. It just seems like we're getting into a particular here that's, it's just not consistent with the way this thing is organized. You see what I mean? I mean, that's why maybe keeping it in one and I just, saying we want especially the scope and standard of review, and then leave what we have now in 2 back where it was before.
So if we added to 1 something like, in particular, agencies should, and I think whatever the language was we called earlier that Aniko was looking at.
Well, I think in particular, agencies should set their scope and standard review to be consistent with the objectives of their appellate system.
Right.
Their appellate, the objectives of their appellate system. If you go down another line.
Line 10. So to be consistent with their objectives instead of agency specific.
Or the objectives for their appellate system.
And then lop off the
because there we're getting into particulars, and it could be that in some systems their goals would make a de novo system advisable, the ones that they have, the ones that do that. I put that back where it was before.
Okay.
I mean, that's just a.
I agree, because this short section seems to simply be saying you should figure out what your objectives are and write your rules consistent with those objectives, and you should make sure you're including your standard of review, but we're not telling people what their objectives should be in this introductory section.
And this is Anika. I think that shortened version works. I think the reason to include the, something sort of in particular about the standard review is to head off that confusion. And I do think that if we're telling agencies to start to do something that many probably haven't, which is to publish something called objectives for appellate review, we want them to make sure they do so in a way that doesn't make things worse, basically.
Okay. I think we've got this in a good spot. So the language that was in, I think it was D5, we'll restore and deal with when we get there. Yeah, it's there. Okay, great. So anything further on what is currently now 1? We can move to B if we're good on 1. Excellent. Let's move to B. So here's our list. We'll start, obviously, we'll start with 1 and the list, which is, I forget how long it is.
I have one suggestion for 1.
All the way to K. Okay, great. Russell.
This is stylistic only, but it's quite a long sentence. It could be reworked, I think, to say agencies possessive procedural regulations should address all significant procedural matters governing agency appellate review, period. Such regulations, often styled as rules of practice or rules of procedure, should be published in the Code of Federal Regulations rather than relegated to non-legislative rules, blah, blah, blah.
Russell, we need you to slow down.
Sure. Well, I just wanted to give you the sense, if you want to pursue it, I can do it slower.
Now, I think it's helpful to get on the screen for everybody to actually see it.
Okay. Well,
agency
and then such regulations, often styled as rules of practice or procedure, should be published in the Code of Federal Regulations rather than relegated to.
Mhm.
Non-lit, and that's it. I just think it's cleaner that way, and it breaks up the sentence so you don't have that real long sentence.
I think agencies, the first word should be a possessive, right?
Correct.
Right.
There you go.
I'd like to chime in because I think that this really ought to be somewhat different. But I think I'm not in disagreement with Russell's basic notion here, but I think that there's a much better way to write this introductory paragraph.
I'm going to put you on pause for a second. Jeff, did you have something on this proposed language?
No, but it's different from what Russell said. Just a couple of other points that might come before what Jack wants to say. So I think that the heading is a little odd. Procedural law of appellate review. Why not just procedures for appellate review? Secondly, I'm not sure that these procedural matters are necessarily all unique to agency appellate review. So I would suggest saying significant procedural matters pertaining to agency appellate review. Certainly a few things on that list would also apply to the first level stage. And the last point I'd make is that I had a suggestion to add another bullet. Yeah, another thing, which would be something like openness of proceedings. I can't read my own. Let's see. Just a second. Openness of proceedings to the public, and any video or video or audio streaming or recording. So something to bring up the idea that was mentioned later in the recommendation about the transparency provision.
Okay. Let's go back up to the language that we had that Russell adjust. Well, first of all, the procedures for appellate review, any objections to that? I think that makes good sense, but open to hear any. Okay. So the language 17 to 22 that we've adjusted. Jack, did you had a thought to rework it? Was that your suggestion?
It seems to me that this is the way it's written. It's a little more literary in style than we normally would want to have in a recommendation. It seems to me that you want to make your recommendation to be sort of simple and clear in terms of what you're recommending. And I would say something like agencies should promulgate and publish in the Federal Register procedural regulations governing agency appellate review.
Well, why don't we keep pertaining to, since that was Jeff's suggestion.
Right. Okay, that's fine with me.
Mm-hmm.
And then these regulations should cover all significant matters, all significant procedural matters. See, I would say pertaining to. I would put governing in the first sentence and then significant procedural matters pertaining to agency appellate review. And then the last sentence, including the following, and then have the list, including but not limited to the following. And I understand the reason for saying not relegating them to non-legislative rules, but as a matter of fact, under APA Section 553, procedural rules are exempt from notice and comment. And so I don't want to take a position on whether that means they're non-legislative rules, because some people equate those two, that if you have to have notice and comment, they're legislative. If you don't have to, they're not. I don't think it's important to resolve that, but I don't know why we need to. I mean, if we say they should be in the Federal Register, that's published this way, that's what 552A1D requires for all matters affecting the public. So I think this is, it tracks the APA, and it's a more direct way of saying what we want, which is we want them to promulgate and publish all their procedural rules governing agency appellate review.
And the word relegated is a little bit pejorative.
Yeah, I just think that they may be non-legislative rules because they're exempt from APA 553, but they are required under 552A1D to be published if they affect members of the public.
And there is a recommendation later, I think, to suggest that agencies should follow notice and comment even if they're not required to. I'm remembering that right. So.
Yeah, I endorse that also, but I just don't know. I mean, there may be a reason. Matt's got his hand up. You know, I may be wrong about this. There may be a reason I'm not understanding, but this was my reaction to the way this was drafted.
Matt?
I agree with, I think I think Jack's edit is good. It simplifies things. I think if I recall, it brings this language into accord with 2016-4, which was the best practices for hearings, at least in non-APA adjudications. But just by way of, just to put something on the table, because everybody may hear about this at the plenary session, and Reeve might want to jump in here. We've spent about, the ACUS has spent about, another committee has spent about 9 hours this fall debating what a legislative rule is and what this is and what that is. And the ACUS does use the term, there is ACUS precedent, and this was done at Ron Levin's behest, but we do use the word, we do incorporate within legislative rules that have external binding legal effect, that is the force of law, even if they may be subject to a 553 exemption. So put another way, in ACUS usage, a procedural rule can be a legislative rule, even if notice and comment is not required. So just you're going to hear about this at the plenary session, probably ad nauseum. So I just want to put this on the table. Reeve, did I get that about right?
Yeah, you got it exactly right. And I think that's a real virtue to the way we have it phrased here, because, you know, we don't really get into that. And Matt's referring specifically to the Rules on Rulemakings project, where we spend an enormous amount of time sort of debating what a legislative rule is, and do we want to characterize rules on rulemakings as such, you know, and how does that fit with the notice and comment and so forth. And so I think the way that we have it phrased here is very, very good in terms of, you know, avoiding wading into those sorts of issues.
Great. Any thoughts on then the new language proposed by Jack? I think it works well. Would we want, yeah, you read my mind, Gavin. Any other thoughts on that?
I like Jack's language. I just don't like the word relegated. I don't know if you want to go there already, but.
Well, I think that with that whole part that would come out.
Okay.
Could in the new language, do we want Federal Register and CFR?
That was just a mistake. You know, I think published in the federal, you know, published in the federal and codified in the CFR would be.
I think the language originally was CFR just alone.
Yeah. However, I'm not up on the technicalities of that, but something, I didn't mean to change anything over there.
But I think the point is that it should be published in both places, one when it's done, and the second for codification.
Reeve, Bill has a good point here. This issue was debated. I hate to keep returning to the other project, but it is a project about rules. There was some debate about this. There was some debate and resolution of how to deal with the Federal Register and CFR in the same sentence. Do you recall what that was? I don't know if it should be consistent or not. Maybe it doesn't matter.
Yeah, so my recollection, I believe, is that we more or less came out the way Gavin now has it phrased here. I think we refer, at least in one place, and actually I'm reviewing that now, and it's suggesting it be the same in both places, to both the Federal Register and the CFR. I think that would be consistent with what we've done there, and I think that presumably makes the most sense as to the way to present it here.
If there's uncertainty, we could add just a comment to, just so that you have it flagged if you need to check.
But doesn't the Office of the Federal Register decide what goes in the CFR? I mean, so maybe it should say, I like putting in codified in the CFR. Because that at least makes it, I mean, I'm not sure how it works, but I think if you've published something as a final rule in the Federal Register, it gets codified in the CFR. But if you publish it in some other place in the Federal Register, it might not.
I think you're right, Jeff, at least, and I'll flaunt my ignorance here, but we've had a lot of rulemaking this past couple of years, and what we've published in the Federal Register ended up in the CFR without us asking for it, and we wanted it there, don't get me wrong, but we didn't have to do anything to make it happen.
Yeah. I think this is fine the way it is now.
A lot of ands, but I think we can promulgate and publish and codify.
I just switched the clauses to be a little more direct.
Yeah, okay.
Codify them. I don't know. Something's a little, we can work on the style, but.
Yeah.
Okay. We good to go on that first intro to the list? Great. So the list, let's start with the list. Anything on the list?
I have a general comment about interlocutory review. When I was reading the report, I always thought of interlocutory review as review of some something that happened during the hearing that might need to interrupt the hearing to have review. But I think the report uses it in both senses as review of like that, or review of the decision itself. So maybe Matt and
The latter was not in, Jeff, if the report suggests the latter, then it needs to be revised. That's not what the intention was, I don't believe.
okay.
But maybe that A could say the timing of review, including the availability of interlocutory review.
I like that.
Any other thoughts on that one?
Nadine, did we want to add?
Chris, yeah, go ahead.
Do we want to add the objectives again? I know it's somewhat redundant as before, but I just wanted to flag that to see what the committee thought.
Yeah, I wonder if we're going to add them, should that be the first or last?
I'd say first.
I'd say first too.
I'll wait.
Roxanne.
Sorry, I was just gonna make another point, so I'll wait till this is done.
Okay.
Well, what I was going to suggest is that for me, or to me, the timing of review is a part of the procedures for review. So one of the things that I thought might be worth spelling out is that the rules should include the procedures for interlocutory review and the procedures for initiating review, because those are usually two different things when the review that is sought is, during a hearing versus the normal review of the lower decision maker's decision. So I'd say instead of the timing of review, I'd say the procedures for and availability of interlocutory review and the procedures for initiating review.
They would be separate.
I think so, because maybe it needs to be maybe B needs to be phrased differently, but I do see them as different things.
Would you consider having the timing of review, including the availability of interlocutory review, and then say the same thing for the timing of review for any post-hearing appeals, so that it's clearer?
See, I think the timing of review is included in the procedures for review, because procedures says you've got 14 days to file, and here's how you file, and that sort of thing. So I think timing is a subset of procedures.
I think that's a good point. So you're thinking A would be objectives, B would be the procedures for and availability of interlocutory review. C would be the procedures for initiating
appellate review, or however you want to phrase it.
Initiating, let's try appellate review, see what people think on that. Okay. Looking for hands. I like that. I like that it mirrors kind of the two aspects in the same way. Okay.
But then when in C and D, are we talking about appellate review each time there?
Yeah, maybe that's, we don't need to repeat that then, or we don't need it initially.
Well, I think we need something, because otherwise it seems like we're referring back to the previous D, interlocutory review.
Well, so let's say to C, the standards for granting review. Theoretically,
why don't we put interlocutory review after the old D there? And then, so the first couple things are about what we call review, and we mean appellate review. And then we add in another section that only deals with interlocutory review after that. Would that be helpful? Because most of these go to what we're calling appellate review.
yeah, I was just thinking that the standards for granting review could be relevant to both. But it might be covered. Again, I'm going back to Roxanne's point that procedures covers probably a pretty broad universe and could include standards for review, for granting review, I should say. If you're going to seek interlocutory review, there's usually, I know at least in our rules, we have, specific criteria that we expect the person petitioning for interlocutory review to meet.
I would agree with that, and I would also note that interlocutory review generally is not where most people want to start, because the standards in general are hard to meet. It's generally not a preferred way of seeking appeal. So I would hesitate to put it up as the very first thing on this particular paper.
Well, maybe that goes to Jeff's point, which is, if we make it its own thing, maybe we push it down the list. I'm sure, I would imagine that in coming up with this, the idea was to kind of track, interlocutory review would come before, at some point during the proceeding underlying what may eventually end up being appealed. But maybe we drop it down.
Yeah, Nadine, I had put it up there just because when I was working on this particular part, my brain was just working chronologically.
Right. But I think we avoid the appellate, using the appellate problem, if, as Jeff's point out, if we strip out the interlocutory piece and shove it down the list. But
And I also, with regard to the, well, there's two right now that are marked as C, but the standards for granting review, if review is discretionary, I like how that is phrased right now because it says if review is discretionary. So that potentially could apply to interlocutory reviews because a lot of times those are discretionary. They may not actually grant review of what's happening in the hearing. So I'm not sure that needs to be more specific because of that, because of the discretionary part. So it could apply to both. And when I say both, I mean appellate review and interlocutory.
why don't we, can we scroll down a little bit, Gavin, so we can see the rest? There we go. That might be helpful to. I think we're good on A. We're going to come up with some language, Gavin, on that with objectives.
Yeah.
Okay. So why don't we delete that line 27? And then maybe that'll help with, no, it didn't. We still have two C's. Okay.
This is Kent. Would it be possible just to combine the two? So you're saying something along the lines of the timing and procedures for initiating review, comma, including any available interlocutory review. I would get rid of the word appellate because I think that's assumed in all of this review that's being talked about. And I would think the preamble is going to narrow us to an appellate program.
I like that. And I think Kent had said availability of interlocutory review. I think I like combining them like that.
I would also add timing, the timing and procedures. That way we're getting, Roxanne, I think your point on there, which I thought was a good one.
Any thoughts on that? So we would delete what is now B, and that would be the new B. There we go. Roxanne, were you concerned about having timing in there, in that procedures would cover timing?
I don't have I mean, I view timing as a subset of procedures, but I don't mind having timing there as long as it's also stating procedures, so that I just didn't like it when it was just saying the timing and not saying procedures, because there's so much more to procedures than just timing, and more to timing than procedures. Stating both is fine.
Okay. Again, we're saving words. I like it, Kent. Okay, so how about C? Standards for granting review if review is discretionary. I know Roxanne has indicated she likes that language. Bill, did you have a comment? I'm seeing your chat. B1C.
Yeah, I had a comment on what was C, but now B.
Oh.
And,
I was looking at C.
I know, but it's a question of whether it should be here or later when they talk about amicus. But the APA provides for interested parties to participate in proceedings, and whether that's as a joinder or whether that's as an interested party that's not a joinder, or whether that's an amicus, it's all sort of up in the air. But the question is, what are the standards by which the agency would allow somebody to participate as an interested party or as an amicus? And I thought that was different than the question of whether or not oral argument would be available to ordinary parties in the ordinary course of events. And I had it up there with this standards for initiating review, because normally when you initiate the review, that's when you'd have somebody who would ask to be an amicus or interested party. But a separate section is fine too, as far as I'm concerned.
So H mentions the availability of oral argument and amicus participation. Is there a way to build in your point there?
Well, I mean, I thought those were two different ideas, and I think the idea of putting the amicus interested party participation earlier and just striking and amicus participation here, because availability of oral argument is just a different issue than whether
Okay.
amicus are going to participate.
That's right.
So we'll take out and amicus participation in H. Do you want to do that first, Gavin? And then we can work on the point above. Okay.
And the addition of D is fine with me.
So it'd say the standards for permitting the participation, and maybe it's too much.
That's good.
For permitting participation, yeah, by, okay. Any thoughts on that? That's a new one.
I think the term amici there, in addition to interested parties, because people know what that means.
Mm-hmm. Okay.
I'm sorry, it's interested persons, not interested parties. Thank you.
Thank you. Okay. And just to go back to C, we decided to leave that as is to the extent that it would cover both appellate and interlocutory. I think that was what we agreed to. Okay, great. So now second D or new E.
Do you think agencies will know what the difference is between the scope of review and the standard of review?
Thoughts? What do you propose, Jeff?
I don't really propose anything other than I'd like someone to explain in plain English what the difference is.
I've often wondered that.
I
I'm looking for consultants, hoping to have them shed some light.
I suppose you could say that scope of review is something like, are you reviewing for questions of law or questions of fact, and then you get into, are you reviewing under the substantial evidence test or some other test? But I don't know.
So when we use scope of review in the report and the way it was used in the agency interviews was actually referring more to whether you are stuck with the administrative record or whether new evidence could be introduced. And this is actually one of the kind of more pressing issues that came out of the interviews, is that a lot of appellate review systems allow the introduction of new evidence. Some allow introduction of new evidence, all new evidence, whatever the person wants to bring, like the USCIS. Others have more tailored rules that only allow actually new evidence, right? Where there's good cause, where the evidence wasn't available before the trial or the hearing proceeding. So I think that's what we're referring to when we say scope of review is it stuck to the administrative record like in 706 of the APA, or are they allowed to introduce additional evidence and supplement the record?
Well, now I'm glad I asked the question, because I think we should be more specific about that. The way you just stated it, raises a specific issue about it.
Well, it's already covered in G.
Yeah. My advice here, I think we could probably, I think it would probably be fine if G does the work that Chris is mentioning, it might be better just to dispense with the scope end. Scope can mean a number of different things in the appellate world, and it's probably more relevant on judicial review. I think it could probably go here if G does the work. That's my just rough sense.
So we would just say they're the standard of review. End of story.
Well, but what doesn't de novo review sort of, some of these appellate bodies use something closer to de novo review?
Isn't that encompassed within standard review?
Oh, you're just taking out the word scope and, okay, yeah. Okay.
Because I think the point being that G does that work.
I thought you wanted to take all of D out. Okay.
Okay. E.
The only thing I was wondering on E was whether we need to reference the record. Whether, because I'm not sure whether it's, I know in some litigation in court, one party is responsible for submitting elements of the record. I'm not sure that that's ever true in agency appellate review. I'm completely unfamiliar with it, but I just wondered that for the people that know more about it than I do.
So you would think, in fact, if
that's a question for Chris. Did you find that agencies had any kind of rules on the assembling of the record for review and who has to do it, that sort of thing?
I mean, one of the big issues, and it doesn't come through in the report as well as it probably should, is that, a lot of agencies have electronic systems for trial, but not a lot, a few, but don't yet have them for appellate. And so they're actually printing out and sending the record. And some of the agencies, and Matt, you can correct me if I'm wrong, again, this isn't in the report, and we probably should add it. Some of the agencies expressed, that this was a big problem for them because sometimes the record didn't come in full, or, they would have to try to get the record from the hearing level. And then, of course, there's also the issue, at least in the ALJ realm, where there is a real separation between the hearing adjudicators and the management, appeals folks, where that is a somewhat of a tension or battle. We don't really focus on that in the report. There's so much we don't focus on the report that we gathered in the interviews. But talking about this makes me kind of realize that is a separate issue that some of them did raise.
Can I just propose a wording change here? In E, after the word where it says "and their required contents" at the end, if we could add the word after required, if we could say "their required form and contents." Because the form of the submissions is important for us in terms of page limit, and et cetera.
Apropos of Roxanne's point, I have sort of just one issue to raise, and maybe Ken has some thoughts on this. I think that agency procedural rules, what I was calling legislative rules, should address these matters. There probably are also details that can be, to use the word that we've eliminated, relegated to like practice manuals and clerk's guides and things like that. I don't know, Ken, do you have any sense from the having been the reporter for the model adjudication rules, whether just to say form and contents is adequate and just sort of leave it up to the agencies to interpret what that means, and when something really should be in the CFR and when it's okay just to put it on a website or a clerk's manual?
I think it's certainly sufficient for the recommendation. And what I think most of them would do, but people on this call can certainly correct me, they would simply put in what I would call a procedural rule or manual like you're talking about. I wouldn't expect to see that in the CFR.
So the APA allows parties to file proposed findings and conclusions, exceptions to the decisions, and supporting reasons for the exceptions. We don't really reference those here. And that's just for APA, ALJ cases, but still, it seems like something like that would fit in here.
Well, Jeff, do those provisions apply to appellate review within the agency or only to the initial hearing in front of an ALJ?
No, those are appellate provisions, aren't they, Jeff?
Yeah.
I mean,
Yeah. All decisions, including, well, all decisions shall include a statement of findings and conclusions. And so, yeah, I think the record shall show the ruling on each finding, conclusion, or exception presented.
But does that apply beyond hearings that are governed by 554, 556, and 557? That's what I'm asking.
In 557. So it's,
right, it is, but does that govern appellate decisions? That's what I'm trying to, because those are the formal adjudicatory procedures that govern hearings. They don't necessarily govern appellate review, where I assume that, most of the stuff in those about presenting your evidence and all that is just irrelevant.
557C says before a recommended initial or tentative decision or a decision on agency review of the decision of subordinate employees, the parties are entitled to submit these things. So beginning of 557C references agency reviews.
So are you suggesting, Jeff, that we need to use that language here,
Well,
or
I would
that
I would include something like, yeah, something about the language, findings and conclusions and exceptions to the decision below, or something like that.
Again, and Jeff, I think I'm disagreeing with you that 557 has anything to do with appellate review, because if 557 is about hearings, that 557A says that it only applies when a hearing is required to be conducted in accordance with 556 of this title. And so those sorts of, I think that those sorts of reviews of subordinates are reviews that are still within the initial adjudication, where there are situations where there's multiple stages maybe within the initial adjudication before you're in the realm of appellate review.
Oh, so I thought 557 had to do with appellate review. Professor Funk, help me out here.
while we try to figure that out, I'm just wondering if,
I'll
obviously
have to look at the text.
It's great to have examples. I'm not knocking examples, but the allowable and required submissions by litigants and their required form and contents. I mean, to the extent that we're concerned about what those submissions would be, I'm not sure that we need, obviously we've got procedures for initiating review. So if you want to initiate review, there are certain things you have to provide. Once you're in the door, there are certain required submissions. For instance, at my agency, briefs are asked for but not required. So there's a range of things that these could be. Are we spinning our wheels if we're trying to pin down an including list?
We may be. We also got to be a little bit careful. I mean, the terminology is going to vary from agency to agency. A lot of the APA agencies do use exceptions to refer to appellate filings, but other agencies don't. So we got to be a little bit careful about the terminology here.
So if we took out everything in between the dashes, just a suggestion. If we're trying to sort out what all of those possibilities might be, maybe not all of them, but some of them even.
That may be the best approach.
Can I just ask, is anyone out there aware of a situation in which there's an appellate review? Like if you take an ALJ case to the NLRB, are you allowed, do they feel that they're bound by 557 to allow you to submit tentative findings to the board itself, or is that something that only applies at the ALJ stage?
I don't know what people are thinking. I know our rules say what they can file, and we allow them to file exceptions to an ALJ decision.
But not findings. You don't submit findings at the NLRB to the board itself. You submit proposed findings maybe to the ALJ.
Yeah, that would be more likely in a post-hearing brief to the ALJ.
Right, right.
I like the suggestion to take the language out of E, because at the end of the day, this is a recommendation to agencies, and agencies will know what submissions litigants file with their agency, and they can fill in the blanks.
We can carve out time to sort out for sure. We'll let the professor do some research. The professors, we have more than one here, so and you can get back to us on that.
Oh,
We'll take a look at this. We'll take a look at this before the next meeting, but I can tell you the terminology is really all over the place. It'd be very hard to encapsulate it.
All right, we'll leave E as is. Let's go to F.
Well, I just want to say one thing about what we were just talking about. In 557B, it talks about on appeal from a review of the initial decision, the agency has all the powers which it would have had in making the initial decision, et cetera. I mean, that's clearly about the appellate stage. And the Attorney General's manual on the APA says that the provisions of what used to be Section 8 govern the procedures subsequent to a hearing. So I'm still looking for, and then it talks about appeals and review in here. I mean, this is a rather fundamental point that I may have misunderstood all these years, but no. That's addressed to Jack, so.
Jack is silent. So we're
No,
gonna.
I'm sorry. I understand that that's part of 557, but I don't think, I've never heard the suggestion before that all of these individual procedures are something you repeat on appellate review. I just thought that, it says before a recommended initial or tentative decision or decision on the agency review of a decision of subordinate employees. I just think I think that's about the hearing. I could be wrong, but I don't think anyone does this. Not that I know of. I've never heard of anyone doing this. So I understand what Jeff is saying, but I think it's not. And I think the language that suggested takes care of the issue anyway, just by deleting those things.
Okay.
All right, we'll move on to F, the procedures for designating decisions as precedential and the legal effect of such designations. Any thoughts on that one? Sold. G, the record on review and the opportunity, if any, to submit new evidence. This is a point that we talked about earlier with the scope, and maybe this takes care of that effectively. Great. H, the availability of oral argument, period. We're stopping there. I, the availability of and procedures for, which is great because we mirror, I think that mirrors the language we had above.
On the one about the availability of oral argument, do we want to say oral argument or do we want to say oral presentation or something that's a little less legalistic? Just a thought.
I know, I mean, I can speak only from my agency's perspective. We call it oral argument.
So do we. That's what we call it in our rules.
Same with FEMSHIC.
The only reason to, one reason to think about that suggestion is that the very traditional appellate systems are going to use the word oral argument. There are, of course, appellate systems that look, have sort of a hearing component to them, and they may not use the word oral argument. So I don't have a strong opinion on the matter, but there is some rationale for Renee's suggestion.
What if we add, I mean, Renee, what if we leave oral argument but add some language to account for that possibility?
That's fine. That's fine with me. I just think argument makes it feel a little bit narrow.
Yeah. I'm going to defer to Jack on whether I'm using and or here. And other options for oral, I don't know, I'm just, oral presentation or some, I mean, so other presentation option, I don't know, throwing out language. Any thoughts, Renee?
Well, maybe you could just say the availability of oral argument or presentation. I don't know. We need more than that.
I would use or in this case, just to chime in on that issue.
So oral argument or, I guess I'm thinking oral argument just has such a very specific, or other, I mean, that's why I'm trying to think of a way to say other or another, other type, other, I don't know.
Well, I mean, another way to think about it is to say, to say the availability of oral presentation or argument. I mean, if you flip them, that might solve that problem. I don't know.
Another form of oral presentation takes care of it, but whether that's too many words to make such a small point is a question.
Right.
Other form you suggested?
Yeah, oral argument or other form of oral presentation.
That's fine. It is kind of wordy, but we could think about that now that we have the concept there.
Yeah. I like that. Okay.
Yeah, and I'd say that at least for our agency, oral argument, we have a procedure for people to request it. We rarely grant it. And once in a blue moon, we will have a public hearing. And then it takes the form more of an oral presentation. So I like the way it is now because oral argument is first, and that's the primary thing that people will ask for. Once in a blue moon, we'll hold something that you might call an oral presentation.
Great. Okay, sold. Let's go to I, the availability of and procedures for reconsideration.
Nadine, I had a comment on that.
Yes, Jen.
Yes, this goes back to the point I think that was made earlier by several speakers, but sort of the use of the term standards and procedures with respect to each of these items. And I'm thinking with reconsideration, standards is probably a better word than availability because in almost every case, reconsideration is available. It's not a question of availability, but whether you would meet the standard of, first of all, do you have to provide new evidence, or even if it's not new evidence, some reason why you're otherwise entitled to reconsideration of the decision. So I think in that case, standards might be a better word than availability.
So the standards and procedures for, the only other thought I had was to say if available at the end, but if you're saying that for the most part, I know what we find is we get those requests whether we like them or not, whether we want them or not. We usually
right. It's almost routine.
Yeah. Even if you.
Yeah. And then just the thought is, did you also want to mention reopening? Because that's sort of two different, in our office at least, reconsideration is almost automatic within 10 days, but then sometimes months later, the petitioners will come back and try and reopen the case. And so we have different standards that would apply in those situations.
So add, yeah.
So we don't treat reconsideration as the same thing as reopening.
Reopening. How about that, Judge? How does that look?
Yes. Mhm.
Okay.
I'm just going to throw out an ordering point in terms of, I think that thinking along the lines of chronologically, I think that I naturally flows then into K. J is sort of juxtaposed in there. And I think J may want to pop up to the top because it seems very basic. But I like that I is saying, okay, can you ask this body to review its decision? Okay, after that, how do I get to a court to have judicial review? So I like I and K flowing together, but J seems very fundamental.
You're thinking J needs to move up?
I think it would be good earlier, or either right at the beginning or at the end. But it's
Let's
it's
drop it to
outside
the
of the party's procedure. It's internal procedure.
Yeah, let's drop it at the end just because we're at the bottom of the list, and we can always reorder. So K, any of the exhaustion, any thoughts on that? Obviously, that would need to be a semicolon, not a period anymore, but.
Well, we have one for timing earlier, don't we?
This is meant to cover something else. Kent, do you want to address this? This comes right out of the model rules.
Yeah, with K, the one issue I had, or question more than an issue, was whether it should be a little clearer that it's talking about I don't think it actually has a term, but what I would call matter exhaustion. If you think about Darby, the case that the Supreme Court had about what one has to do to exhaust a matter before going to court, and then also issue exhaustion. The Supreme Court just took a case this week on issue exhaustion, and they're usually treated as different issues. Now, I guess they could all be treated as administrative exhaustion, or is it smarter to parse them out for the agencies so they're thinking about both when going through this?
Parse them out, because otherwise you're going to get a long lecture from Ron Levin at the plenary session on the difference. And I think it is important for agencies to distinguish between the two. I don't know if either term needs some kind of parenthetical definition, but I do think that they are separate concepts. And when I had worked on this list, I had left out issue exhaustion sort of deliberately, but maybe it should be in there.
Matt, my inclination is with your first instinct, because issue exhaustion requirements are really things that are imposed by courts, not decided upon by agencies. Whereas under the APA, either agencies or Congress has to require exhaustion before exhaustion is required. So, in terms of actually exhausting the remedies that are available, issue exhaustion, I think it would be difficult for a lot of agencies to formulate a rule and promulgate it in advance about what issues need to be, what issues can be brought up on judicial review where the precise issue may not have been brought up before the agency.
Kent, you want to address that maybe with regard to like the Sixth Circuit case law?
Yeah, I'm not sure I agree with that, because I think one of the key issues we've seen in whether people can bring challenges to ALJ appointments, if they didn't bring it up in the Social Security proceeding itself, is the fact that SSA has not provided a specific rule on whether you have to exhaust that particular issue or not. And indeed, even between the dissent and the majority in the most recent Sixth Circuit case in September, this was part of what they were debating, was whether or not imposing an exhaustion requirement or not was really a big deal, because the agency could fix it at any time by simply requiring it. So I actually think it would simplify things if the agencies would say, and if you want to preserve any issue for appeal, you have to use it here.
Kent, do you think a rule like that would be binding on a court?
Binding. Yeah, I mean, I think I do. And the only reason I'm hedging a bit is because you have to kind of go back and look at the Sims v. Apfel case, where we're really, kind of left looking at O'Connor's concurring opinion and doing a little bit of a Marx rule idea with it all. But I think that's really where she left us, because a part of this question was the nature of the proceeding and how clear the agency had made it that one of the parties needed to list the issue or not on the forms that they were filling out.
One of the things I think, one of the messages I think, Ken, you know these case law better than I, but one of the messages you get from the courts in these cases, like the Sixth Circuit, is that we kind of wish if Congress doesn't address it, that the agency addresses it by regulation, so we don't have to invoke like prudential exhaustion kind of doctrines.
I think that's exactly right. Yeah, they're hoping the agency will just help them out so they don't have to deal with this every time it pops up.
So is the thinking here we need to be more specific? Is there specific language we can add to address this? To build
my
off what
proposal would probably just be any administrative or issue exhaustion.
Any reactions to that?
Well, I think it's interesting because I can see that also applying internally as well, because we, via our case law, don't allow parties to bring a new issue up on appellate review to our board if they didn't argue it to the ALJ or to our regional director. But we don't specifically state that in our rules. And so if we were to have something like this, I'm wondering if it would help us to do it a little more broadly and say, make it clear to parties that they need to also do that internally, not just once they try to seek judicial review. So in terms of a specific suggestion, which is what you always like,
I was going to suggest that would be appropriate, not in the rules for appellate review, but in the rules for the initial hearing, which is if you want to appeal this decision in the initial hearing, choose here.
Roxanne, you had language you were thinking about, though. Why don't we just hear that and then?
Well, if people agree that it would be helpful here as opposed to appropriate somewhere else, we could simply leave it the way it is now, but just add that must be satisfied before seeking agency appellate or judicial review.
You went exactly where I thought you were going to go.
Okay.
That's what I was, well.
But doesn't that relate to the standards for granting review earlier on? Like in B or C, wherever it was?
Not necessarily. I mean, that you may take, well.
We're not going to grant review if it's a new issue.
Yeah, it sort of applies there, but realistically, people make a whole slew of arguments, and one of them wasn't raised below, so we don't accept that argument, but we accept everything else.
Right.
I think Bill Funk is right that this issue can come up either in the context of hearing level rules and appellate rules. Is this new language here? No, I would draw that. I think the language here is probably okay, but Bill does make a good point that this can come up, and it comes up in the case law. Sometimes the cases the issue is issue exhaustion at the hearing level, and sometimes it's at the appellate level within the agency.
But I think built into would be the idea that before you seek review at the appellate level, you've got to know what arguments you've raised below. I mean, if you're not raising it below, you're not going to be able to seek appellate review of it. So
can we see B or C? Could go up a little bit higher. Scroll up to the earlier ones. What do we say about the standards for granting review if review is discretionary?
Excuse me, Jeff, you could put standards for granting review, comma, including any requirements for exhaustion or something there.
For
comma.
Issue exhaustion.
Yeah.
I don't think that I think those are two really different issues. And I wouldn't mix those two issues. In my mind, they're completely different. And I actually disagree with the notion that what we're talking, issue exhaustion has anything to do with rules of procedure on the initial hearings. But the initial hearing, obviously you can't ask for a jury instruction or something, or propose a finding on an issue that you never raised at the hearing. But that's not really exhaustion. That's just a basic rule of civil procedure. I think that when this issue of issue exhaustion comes up in litigation, when an appellate court says, well, you waived that issue because you didn't raise it below. And I suppose it could happen on a post-trial motion too in court, but it's really, what we're talking about here is a basic fundamental issue of appellate procedure, not an issue of trial procedure. And I don't think it has anything to do with the standard for granting review, except insofar as an agency might say, well, the only error we see that's possible is an issue that you didn't raise, but that's not really something that most people would think of as part of the standards for review. I think the new language is really good because it encompasses both internal agency appeals and judicial review, and it belongs in both. So I think the new language is fine. It takes care of the whole problem.
Yeah, I was just going to say, I think the idea is we don't want to hear any new arguments on appeal. We just don't want to hear them. If you didn't raise it below, then don't bring it here for the first time. You're going to lose. And that goes for the court too.
Well, that's not completely true though, is it? Because what if you have an argument that you couldn't have raised below?
Right. I think it's about whether the judge had an opportunity to pass on that argument below. So that doesn't mean that you can raise a new argument necessarily. Or if it's inextricably intertwined with an issue that was raised below, which is arguably new, but might not be.
The judge's decision shows a bias.
Or new evidence.
I don't think that the language takes care of that, because that wouldn't be an issue exhaustion requirement. That's a new issue. I mean, that's clearly not, I mean, in other words, the language in K now says what traditional, it says, tell us what your rules are for issue exhaustion. Now, that's good enough, I think.
Okay, well, it's a little out of the chronology, but I think the language is okay. It's just messes with the chronology a little bit.
Well, I think we can play with chronology once we get everything nailed down. And Michael, that's a good point. I mean, it's really the opportunity. I think that's how our rules are phrased. It's probably how FEMTRICs are as well.
Yeah.
We will not ordinarily pass on decide an issue that the judge has not had an opportunity to pass on. So.
Right. And I also agree with the earlier comment made that this should not necessarily be subsumed with the granting of review overall per se, because as was mentioned earlier, you can have a whole slew of issues that are presented on review and you just grant review of the whole thing, then maybe say this specific issue wasn't raised below, so they've defaulted on that claim because the judge did not bring an opportunity to pass, but they still granted review overall. So I wouldn't fit that in there personally.
Well, I say we leave this as is for now, and
can I just make one comment on the chronology point? That the J, what is now J, the multi-member board thing, it goes to the issue of where the appeal goes, and where the person needs to file the motion, where the appeal goes. And so that seems to me something that should come earlier. But somebody, just something for Chris and Matt to think about when they're revising this. That's all. I don't want to toy with it now.
Okay.
Or Gavin, this J provision kind of this is an observation I had, that a lot of the delegations don't appear in the rules, and they're not always that easy to find. And this sort of tracks Title 28's provision governing appellate panels. So.
This is Anika. I had one tiny suggestion on that same, on J, where it says, and the like. I suggest that we change that to, and similar bodies or something like that.
That's much better. Okay. So I think,
I'm
are
going to
we,
go back to L&M because I suggest, I think you can combine those two and say openness of proceedings to the public and availability of video or audio streaming or recordings.
Agreed.
nice.
And maybe that needs to be placed at a different point too, but I'll leave that to you.
Yeah, we can work on the order, I think. Are we done with the list? Because if we are, I think that might be a good time to take a quick break before we dive back in.
One other thing I wasn't sure if we should include in the list is on the idea of the availability of video or audio streaming of the recording. Would we want a point that addresses the availability of video or audio hearings? No, that'd be the hearing level, not the appellate level. Never mind, I rescind my comment.
Okay. All right. I think we're done with the list. Let's take a 10-minute, what is it? 3:30? No, yeah, let's do 10 minutes and be back at 3:50, and then we'll go right into 2. Does that work for everybody? It's gonna have to. We're taking a break. All right, we'll see you back in 10. Thank you.
This conference will now be recorded.
We'll get started, I think, in about a minute. Give people 1 more minute to get back.
Hey, Ken, what's the name of that Sixth Circuit case?
Ramsey
Ramsey, okay.
versus.
Hey, Gavin, could you show the end of 1 again, just for a second? I want to see what we did at the end of 1.
He might not be at his computer.
Oh, okay.
And I can't do it, or I'd do it for you.
I can't really see people's photos very well. It just said we came up with the word body, and that struck me as a little odd there. I don't know. Can't think of a better one. Reviewing officers or something.
I wonder, Jeff, if I think it's 83.3, whether there's any language in there that might be useful here.
83.3.
The one Ron Cass was a consultant for.
Oh, right.
Yeah.
Yeah, there might be. Have you talked to Ron about this?
No.
You might
He's
send
aware
it
of
to
it,
him.
but not the details.
Mm-hmm.
There's Gavin. Jeff, can we table that point, or do you want to?
Sure. Of course, sure.
Table it. Okay, great. Let's get started on 2 on your screen. We finished our list. I think it's in good shape. We may need to reorder it, maybe tweak it a bit, but we've got time for that. So let's get moving on to any thoughts here?
On line 53 should say each program's review authority. Is that what we meant? for agencies that have more than one.
Chris, Matt, any thoughts? Yes, no, you can. Okay. Matt said he would only speak if he had an objection, so.
Yeah, that works.
Any other thoughts on 2? Okay, let's move to 3.
It says this report. Well, it's not going to be an appendix to this.
Yeah.
One question for the committee on this point, and Ken, correct me if I'm wrong on this, but the model rules were specific to adversarial adjudication, correct? Would the same principles, do you think, apply to appellate review in non-adversarial circumstances?
I'm trying to remember enough about the appellate ones. I mean, I think they would still give you a pretty good template, just because they're dealing with briefs and they don't go into so much detail as to go through like the order of briefing, you know, kind of like the order of battle with it all. So I think they would still be useful, at least as a template.
And Jeremy, to further to the point, and maybe there needs to be some as applicable in the prior list, but that list includes every subject that's addressed in the Mars appellate rules. So
Agencies should consider the appellate rules rather than review.
I thought the same, Jeff. Okay. 4.
Do we need the word voluntary?
Reed, you want to jump in on this one?
Yes.
This particular language comes from elsewhere, so could you explain?
Sure. Yeah. So, yeah, the reason why we phrased it this particular way is rules on rulemaking. Again, the issue came up where we basically, to the extent that there are procedural rules or policy statements that don't require notice and comment, that we have passed ACA's recommendations that encourage agencies, at least in the case of procedural rules, to go ahead and seek public comment, but not necessarily the full notice and comment process under 553, but you should solicit public comment. So we phrased 4 in a way that fits with what we did in that recommendation and what we've done in past recommendations in terms of what we're asking agencies to do with respect to voluntarily soliciting public comment, and how we construe that to be broader than just, you know, going through formal notice and comment. They can also seek public comment, but not necessarily go through the full complement of proceedings, you know, under 553.
Can we just say procedural rules exemption without the hyphen?
Okay. We'll move to C. No.
I had one comment on number 4. I know that we have, like, at the end on line 63, you know, this idea that, you know, you wouldn't necessarily always encourage agencies to do that. There's a weighing, but I also wonder whether it makes sense to include in line 60 when adopting significant new or materially amending, because you know, there are things that you do like that are very minor if you're just doing sort of a cleanup of your regs that, you know, I don't see that the comment procedure would be, you know, would serve any purpose for. But then if you're talking about something like you're changing the scope of, you know, the standard for review or something like that, or how it all works, I can see doing it. But I just wonder if we might want to use a qualifier there.
Wouldn't the cost benefit analysis take care of that?
I think it does to a certain degree, but like it still to me doesn't get at the idea that, because like for example, if you're going from a 7-day period to appeal something to an 8-day period, right?
Well, for our
I don't know how
agency, a
you
couple of years
exactly
ago, we
measure
did
the cost benefit analysis of that, even though it's a pretty minor.
an example I can give is our agency a couple of years ago did a sweeping review of our rules. Our Federal Register submission was like 163 pages, but it was all stuff like taking out references to telegraphs and carbon copies of things, and very, very minor that I can't imagine anyone would submit a comment saying, no, you need to still maintain the ability to receive things by telegraph. So I agree with including the word significant.
Any other thoughts? I mean, my only concern there would just be, I think materially amending might cover the concern. If you're making minor amendments as opposed to creating something brand new. The examples of deleting telegraph to me are not material amendments, but.
That's true. That's a good point. Material part. Maybe enough.
So you're saying that if it's new, it's probably significant.
It's possible, I guess. I'm trying to think of an example. If no one's ever seen it before.
You have to pay your filing fees with Bitcoin.
I'm fine with leaving it. I just wanted to point that out, that some of the examples to me seem to be covered by materially amending as opposed to something that's brand new. I do think the agencies are going to make that call.
Well, do you think we should have new in there? I mean, are there any agencies that don't have procedural rules that are published in the way we envision in this document? Or, because if they don't, then, we would need to say new. And I agree, I do agree that material probably takes care of the, kind of de minimis changes, but, you could think of things like, this is the whole procedural substances debate, whether you're gonna, relegate people to video conferences unless, or to 3 cities in the whole country for in-person hearings or things like that. So the agency may think, hey, wow, we're just streamlining things. I'm not saying anyone thinks that here on this call, but for the public, that's a really big, significant change. And so I guess the point I see the point of 4 is kind of sort of reinforcing that whatever you do, there has to be some opportunity to make, or some to make the public aware of what the change is.
Don't forget, in the beginning of number 1, we talk about all significant procedural matters. Significant procedural matters include all these different things. So we've got the concept of significant in the very first in B1.
Right.
So just to
Matt, Chris,
provide a little context, there are agencies that we're recommending that they promulgate procedural regulations because they don't have them. And some agencies don't even have non-regulatory regulations. The practice rules for some are actually quite bad. I think adding significant before new really kind of confuses things, because if they're doing completely new procedural regulations, like a whole set of rules of practice, I think the only way you'd be kind of making minor changes would be to amend the existing rules. So I would prefer not to have significant there, because I think that really does confuse the process of actually promulgating a set of rules when you've never done it versus amending rules to add or subtract or to change the ones that exist.
I agree with that statement in whole.
I agree too, especially since one uses the word significant twice.
So significance out. Is that the consensus?
You might consider phrasing it the way number 3 is phrased, by saying when materially revising existing or adopting new appellate rules. That makes this clear distinction between brand new rules and existing. I mean, it at least would be parallel to that, or you might even take 4 and put it as part of 3, follow on of 3.
I think I like it separate, but I always love the idea of parallel construction. So if we could do that. So it doesn't seem like we're introducing something new. And do we want to say procedural regulations or appellate rules? There's 2 different descriptions there. 3 uses appellate rules, 4 is just procedural regulations. So maybe we pick one and use it in both places. Any votes for one over the other?
Can I just ask, in this new language that are we losing the word materially?
No, put that back in.
Should be in. When materially revising, is that what you suggested?
If you're limiting it to appellate rules, then it's more parallel certainly, but as it's written, it covers all procedural regulations that agencies issue. So, which is consistent with our earlier 92 recommendation. I don't have a strong feeling, but
I would say we should. Go ahead, Jack.
I would just say I think we should confine this one to appellate rules. We're not commenting. This is not a recommendation about anything other than appellate rules. So I think using the exact parallel is the best.
Okay, that's fine with me.
Okay. Anything further on 4?
Nadine, I missed the discussion on 2. If I could just go back to that.
Let's do that.
And I just thought, rather than agencies should consider including, we should say agencies should include.
Was there a reason for the consider, Chris or Matt?
No, other than that, this is something that there's a decent amount of variation with respect to agency practice here. So we were just trying to build in a little leeway for agencies, but I don't have a strong opinion one way or the other, and Bill's change sounds fine to me.
Same here.
Take out the should.
Yeah.
Oh, should include. Okay.
No, you
All right.
need, yeah,
Should
yeah,
include.
yeah.
Yep.
You need it.
Yep.
Yeah.
Good. All right. Thank you.
Okay.
While you're looking at that one, I don't like the word bodies up there. I think entities might be better. We have read too many.
What line?
It's J, 48.
Oh, up here. Oh.
Yeah. Entities, was that what you suggested?
That's what I was suggesting.
Oh.
I don't know.
That's fine with me. I didn't, bodies didn't bother me, but I'm trying to remember who suggested it.
And of course, it isn't J anymore, and it's and you don't have a semicolon and at the end anymore.
We can clean that up. I have a feeling we'll be revisiting the order of this.
As a technical matter, also, a typical ACUS convention is to number the recommendations in the entirety of the document. So we will probably revisit renumbering everything from 1 to the end of the document.
Great. All right, let's move to C. I think we're in good shape. Anything in the first recommendation there?
This is Russell. Just wondering. C1 talks about standards. The commentary though refers to criteria. Is there a difference there? Or should they be consistent, or does it make any difference? Criteria for granting review, standards for granting review.
I like criteria. That tends to be how we view it.
I'm just asking whether, I think it's better. I just think whether it should be consistent with that extended commentary.
And on that same note, for consistency, should we make purposes into objectives so that it tracks?
You actually read my mind there. Because that's what we say in the first line, yeah.
Maybe you have to comment?
Yes, Judge.
Okay. It was a little confusing to me in C1. And so in the second line there, I think a good word to insert there might be the granting of review. That based on the agency's specific objectives for appellate review, agency should consider whether the granting of review would be mandatory or discretionary. Not that whether the review, whether review is mandatory.
Okay. Any other thoughts on 1?
Assuming they have the statutory authority to consider, to do so. I mean, what is that referring back to? To do so, it refers back to consider, but it doesn't quite work.
Decide. Should decide. I mean, that would be the only thing that, if you have the authority to do that, to make that decision.
Yeah, it's better.
Okay, that's a good catch. Anything else there? Okay, let's move to 2.
This is Russell again.
Yeah.
On line 72, what is them referred to?
I had the same point, yeah. It refers to agencies, but it shouldn't.
It's unclear. The antecedent is unclear.
To the appeal, the body, sorry, the appellate.
Yeah, okay, all right.
Does that solve that?
Yeah.
I think that solves that. But also the interlocutory review comes up again here. We're not just talking about interlocutory review, we're talking about review, mostly. We're talking about appellate review. I mean,
it's both, right?
It's both, but interlocutory review is much less common than appellate review.
Is that covered in the first line? So sua sponte appellate review. And then also
Yeah, the second half of that is talking about the hearing level adjudicator seeking review. And so that would be interlocutory, wouldn't it?
It doesn't have to be. You could have
That's
recommended decisions, and I think some systems have it. If it's a novel issue, you can refer it to the appellate body. So I'm not sure it has to be interlocutory.
So
for appellate or interlocutory review?
Appellate review, interlocutory review is a form of appellate review as I see things.
So you would
Yeah.
just take out interlocutory, just say review.
I mean, this was based, just to kind of provide some context in the report, this was based more on interlocutory review. As Jeremy was, I guess he's not calling it interlocutory, but there are a number of agencies said it was a best practice that ALJs or hearing level adjudicators could actually kind of certify a case in the middle of it and just say there's a unique issue here that we could get guidance from. So instead of deciding the case, I'm going to pause and send it up, let that issue be decided. Sometimes the appellate body would actually decide the entire case and not send it back, right? Because they can do that. Other times they would send it back after they decide the issue. So I'm not sure what the right word is, but I think if you take out interlocutory review, it kind of loses.
So why don't you say cases or interlocutory issues?
That's a word.
Judge Manuel, did you have something on this?
Yeah, and you know, Jeff mentions this a couple of times, and I kind of get the point, because there seems to me that we might be able to make a distinction in certain parts of this between sort of appeals as a matter of right and appeals that are more of discretionary appeals. Where discretionary appeals, it's true, those tend to come up not quite as often. Whereas there's a whole set of rules that apply for appeals that you would pursue as a matter of right, because there's a final order and you file within a certain amount of time, and you don't really have to have a basis for it, you just can appeal. Whereas discretionary appeals would require you to meet certain standards, even to have a basis for filing the appeal, let alone to prevail. So that kind of distinction is something that we might look at when we're construing each of these requirements. I think it does cause a little bit of confusion, which I would say, by the way, I wanted to mention to Chris also that what I liked about this whole report is that there's a lot of teaching going on here. It sort of gives you the list of possibilities in the universe, and that's very helpful. But I do think that they're in places that we can be a little more specific about what kind of appeal we're talking about.
I'm happy with the language as it is. And I should have said earlier that I really like the report too. The report's great, but I think this settles my concern.
Yeah. I would just make one suggestion, which is change it to either interlocutory orders or interlocutory decisions, because I don't think there is any such thing as interlocutory issues.
Orders. Okay.
Interlocutory orders or interlocutory decisions.
I mean, the key here is a lot of times there is no decision, right? I mean, they're sending it to the court to say, or to the higher appellate body to make a decision. I guess that's an order. I don't know. It's not even an order. It's a request, certification request. So I don't know. Issues seem to be a little bit more accurate, but.
Chris, do you mean the idea is that they're asking for a ruling as opposed to review of their own? Usually we see it in the context of the ALJ making a ruling or order or decision on an issue, and then it's brought up to us. You're saying the judge kind of stepping back and saying, I don't know what to do here, I'm going to send it.
Yeah, my understanding, I could be wrong, and Matt, correct me wrong, from the interviews, and I think from a couple agencies actually, when they talked about this, it was, we didn't even decide the issue. We thought it was an interesting issue, and so we flagged it and sent it right up. So
why not change the language to just issues?
Well, what about saying refer cases or certify issues for interlocutory review?
I would take out the certify because it might not be a certification process. I would just say refer cases or issues.
Just I think, okay, so without the interlocutory.
That works for
adjective.
me.
Matt, did you have
But
a
it-
comment?
No, the model adjudication actually has a good discussion of the various ways in which interlocutory review can operate, but I'm okay with this.
I'm okay with it.
Okay, great. Let's move to D1.
On line 74, if they're integrated, it's just one system anyway, isn't it? Single or integrated electronic case manage, a single or integrated electronic case management system.
Well, I think what we're trying to, I think what's trying to be said here is that you would have separate systems for hearing level, appellate, or integrated.
Yeah, maybe separate or
But if they're integrated, it's one system, isn't it? Isn't that what integrated means?
And maybe separate, better word than single. So you either have two systems or you have one that incorporates both levels.
It just struck me. I don't want to push the point.
Matt, Chris, any comments on what was meant here?
I like
If
separate.
people are uncomfortable, you could take out a single or integrated and just agency should maintain an electronic case management system.
So Roxanne, do you have a comment on this? I know you have a great case management system.
I was going to just suggest the same thing, to take out single or integrated and just say maintain an electronic case management system for both. Because the important thing is that the system's designed to ensure that hearing records are easily accessible to appellate adjudicators.
Gavin, is this thing in sync with the recommendation that we issued on ECMS?
I was just thinking about that. I think the idea behind an integrated system is that I know that there are agencies that would have two separate systems, and sometimes they would make a decision just increase the bridging between the two rather than creating one single system to rule over all of them, which can be pretty expensive. I will definitely go back and make sure that this, whatever we end up with, squares away with the ECMS recommendation. I think it generally does.
We had 11 separate systems before we adopted our one single system. So that would have been tough to bridge. But no, yeah, the point is basically the second half of this, which is that we're not shipping boxes of documents around like we used to.
Which the big benefit is allows for more than one person to process or work a case at a single time. That's the time saver.
Is it for both hearing level and appellate programs? I feel like something's missing here. Systems for both hearing level and appellate.
It seems like that language is superfluous about hearing level and appellate once we have deleted the language about single or integrated. So maybe the best recommendation would be agency should maintain an electronic case management system that ensures that hearing records are easily accessible to appellate adjudicators.
Gavin,
Yeah,
we got to be careful here about going beyond where I mean, I think the committee should consider maybe the next time what the prior recommendation says and whether we're going beyond that recommendation here.
We can check that.
But I think Jack's suggestion is to make it more general. So.
But I think Matt is correct though, that the idea that we're recommending that they that they have one system. I mean, I don't mean it to say that they have one system. Whenever possible, agencies should maintain electronic case management systems that ensure that hearing records are easily accessible to appellate adjudicators. That leaves open the possibility that they have more than one, right? Because some agencies, we're not trying to tell them they have to have one. And we don't, I mean, caring whether they're integrated or not, whatever that word means in this context, isn't important. What's important is that the records are easily accessible.
That would make it more general.
Yeah. No, I like the more general approach. I mean, I just think the idea is that oftentimes, there's kind of that barrier between the lower level and the appellate level and access to certain materials. Obviously, case records are foilable and available. The idea is that there's easily accessible records. What we found in our system is that when a matter came up on interlocutory review, back in the days when we had paper, obviously everything was still with the judge. And so we wanted access to the materials and the records, and, they guard them with their lives. So with the ECM that we have, it's really great. We can just go in and find the records. It is easily accessible. I'm happy to say we meet that one.
I had a quick question about D1 as well, in line with what we were talking about earlier in terms of the target of this recommendation. I just wonder whether it might make sense to have some language regarding e-filing in addition to case management. Just, this may be beyond the scope of what we're dealing with here in this rec and our CMS, but recommendation. But I just wonder whether it might make sense to say, to consider this recommendation to target not just the agencies themselves, but also to be of benefit to the litigants, as we talked about earlier, perhaps from an e-filing perspective. And I wonder if we could have some language at the end of paragraph 1 that could possibly account for that, specifically e-filing, as it could benefit accessibility to the litigants at the appellate level. Just a thought.
I like Jack's recommendation, just going back to what he was saying, we're getting rid of the bulk of it and just leaving whenever possible should maintain an electronic case management system that ensures that hearing records are easily accessible. And I think the significance of that is that there are a lot of electronic case management systems out there that do not manage records. They don't manage documents. All they manage are the data with regard to the cases. And so the point is that the records are available, as Gavin was saying, that people can access the records.
Any thoughts from Chris or Matt on the possibility of adding an e-filing recommendation here?
Yeah, I don't know if it goes here, but I don't have, I mean, not that I don't have a problem with it otherwise.
Same.
With the caveat that not all ECMS systems, of course, for agencies deal with e-filing. Some are just ECMS, period. But maybe the language could account for that if we choose to deal with it.
Any thoughts for language there that you would propose?
I'm thinking.
You could add the words filing. So you can say whenever possible, agencies should maintain electronic case filing and management systems that ensure that hearing records are easily accessible to appellate adjudicators. Although that, I guess it doesn't really go to the filing of appellate documents.
Yeah, I'm wondering how we would tie that in. I really do think the work being done here is making sure that those records are available when something goes up on appeal.
So maybe this goes in the list above. You know, that maybe we need to add just an item in the whole list about that this all should be done electronically.
Again, the other thing too is you have a resource issue, although I think most agencies are doing this, or at least on the road to doing it. Although Matt would recall, I think Jeremy as well, at the council first meeting, electronic case management systems came up, and I think e-filing as well. So I think there are many
That's why it's contemplated down below as a subject for agency interchange at the page 5.
Well,
I don't
maybe
think,
we,
go
well,
ahead.
yeah,
I just think this one, I think we do, this might be one, my advice here would be to do what perhaps we haven't done adequately and look at the other recommendation, because I'm concerned
okay,
that we're not in sync with that recommendation.
all right. We'll leave it in as, we'll flag it and think about whether there's a way to build that in and make sure that it's consistent. That works. Let's move to 2. And I know there's a comment here about screening. Maybe it would be helpful for Chris or Matt, both of you, to talk about what the concept is here in terms of screening.
Matt, do you want to or want me to?
Why don't you go ahead? This is one of your favorites.
So Matt's wanting me to step in this. Fair enough. I mean, so in our interviews, a fair number of the appellate systems folks talked about a best practice they have of both screening and grouping. And what they mean by screening is that when the case comes in, they identify either through staff attorneys or some use artificial intelligence to figure out the subject matter, if it has a common issue, how difficult the case is. And based on those factors and others, they would then send them to different adjudicators for, to leverage agency expertise or economies of scale. Some places, like the Board of Immigration Appeals, would send the very easy ones to one judge panels and would send the cases that look more difficult based on that review to 3 judge panels. That's kind of one example. Other agencies would just send them to different staff attorneys to work up the case first, just based on kind of grouping around that agency expertise. So when we use screening methods, the idea there is to try to kind of look at the appeal at the beginning and decide which track to put it on or where to send it. So that's that.
It's more like efficient intake or something like that. I mean, screening sounds a little bit like you might be rejecting some of them.
Yeah, it sounds like it just sounds like good case management, right? Maybe there's better way to describe it and not use the
Screening's a pretty
Maybe,
used term.
maybe instead of saying screening methods, it could say case assignment methods.
Russell.
Sorting?
No, I don't think case assignment, that's a different matter. I mean, I think multi-judge courts, the screening is fairly accepted as basically putting cases on tracks, different tracks for different cases. And for that reason, I suggest, I don't even know why we need the word where appropriate, because it means what screening is all about is about groupings of appeals on the various criteria identified there. I would say agencies should consider implementing screening methods for appeals by grouping appeals on relevant categories such as the merits, so on and so forth.
To the extent this is a method, I mean, this is something I'm not familiar with. At our agency, we don't do something like this. Are you thinking more about mass, big programs, big adjudication programs where they're trying to streamline and assess a case and put it on the right track? If screening method is a terminology that you heard from agencies, or is this something that comes from the courts?
The latter. In my case, the latter.
But I'll say it again. I think screening connotes that somebody's going through them to decide whether to take the cases, and that's not what we're talking about. I don't even know if we need it. We just say implement methods for the grouping of appeals.
For assessing how to group? I mean, I don't, it strikes me as it's something, it's not screening it, as you're saying, it almost has a pejorative sound, but if it's coming from the courts, is that something we should make explicit? Chris, did you hear this from agencies you're saying that do this or call it that?
Yeah, this is what the agency said. If Matt can correct me if I'm wrong, this is how they framed it, is that they had initial screening to decide which track to put things on. Yeah.
Yeah, screenings and tracks.
The word screening was used if it's too loaded for Jeff, but we actually had this discussion about this very word, Jeff. If it suggests weeding out as opposed to putting something in a group for any number of reasons, like order of decision or whatever, maybe we should come up with a different word.
Well, you already have it in there. It's grouping.
But it's grouping. No, grouping suggests aggregation, and that's it's similar, but it's different. This is more sorting or
sorting.
You could say.
Well, I have to say, I know you rejected this suggestion, but this is how we do our case assignments. Someone in my office reviews the case and determines, is it like something else we already have? It should go there. And is it something that I can group some together? It goes to this place. It's a part of our case assignment process. And that's, but it's not screening anything out.
Methods of intake for appeals.
Implement intake methods for assigning appeals.
How about reviewing methods for appeals?
I make one last plea for something like screening methods to group appeals according to.
That's good.
Screening methods to group appeals according to, and then, you know, I don't know if we can actually do all the language here, but according to such criteria as, you can cut out most of that, as, you know, difficulty, common legal issue, subject matter.
I will note that does change the meaning because the original text said implement screening methods and by where appropriate the grouping of appeals. And so it suggested that screening was different from grouping. And here it's now, I think it is making screening and grouping mean the same thing.
Hey, Dean, I have an offer if the committee wants it. If you would like Chris and me and Reeve and Gavin to play with the wording here, we could certainly do that before the next meeting. I'm just trying to help you here.
That would be great. Take the help. Yeah. It's 4:34, so
Can I toss another word into the mix? Does docketing help at all? And, you know, as you think about it, I'll just toss it in for your consideration as you wordsmith this.
Yes, and if you're going to be wordsmithing it, I would throw into the mix. We look also at long record cases and we assign those slightly differently. So that's something else that we try to look at.
Can I suggest putting where appropriate back in, but at the because there's lots of agencies, appellate processes who just don't have enough cases that this makes any sense.
I second the same reasons.
And I would say also is that you may want to put in the notion or consider the notion that they should not, these so-called case assignments should not be made on the basis of inappropriate considerations. And certainly not to say, you know, political considerations or things like that. But the idea is that a lot of judges and agencies aspire to the notion that these cases, to the extent possible, are randomly assigned on a case rotation basis, and not on the basis of, oh, who's the best judge should I give this case to? So I think that should be a consideration somewhere in the language wordsmithing.
But we're talking about the appeal stage here, so there's not likely to be too much. Well, in many agencies, there won't be rotation.
We actually have rotation, and it's a big deal. And so I think that's a very good point that you raise. And actually, our long record case, we have a separate rotation for long record cases, so that the same staff doesn't feel like it's getting too many big cases that are difficult and complex. And on the idea that of fairness and appropriateness. And we had our IG look into it. Our IG reviewed it at one point about a decade ago and said that there wasn't enough randomness in how the assignments were being done at that time.
Should it be size of the record?
Okay, wait. Judge
Size
Manuel,
of
go
the,
ahead.
I would just point out that there has been litigation on that precise point in the federal courts and how cases are assigned and case rotation involving ALJs.
Jeff.
should it be
I
size?
would,
Jeff, let's do
it
Jeff
seems
first.
to me that maybe, it
Jeff
seems to me
first.
that maybe what we should, oh, I'm sorry.
Jeff, wait 1 second. Jeff.
I just wanted to say size of the record might be better than length of a case.
Okay. Jack, you're on.
It just seems to me that at the end of this, maybe we should give the positive case for what we're trying to do and then have a phrase, something like, without compromising the principle of random assignment or something like that. You know, without going into like casting aspersions on anyone. I think just, you know, not compromising that thing. And the only other thing I would say is I would suggest not using the word leverage and instead use utilize in terms of expertise. But that's just my own, it's another one of my own little things about words like leverage.
I guess I see it more from Roxanne's point of view. This is good docket management, right? This is good, you know, making good, efficient use of the resources you have based on the cases that come in. So screening is unfamiliar to me, but if that's terminology that agencies have been using, my only thought was if we stuck with screening, do we tie it to the courts in some way? So that nobody thinks we're trying to make something up here that someone might get the wrong message from it. All right, is that enough for Matt and Chris and Gavin and Reeve?
Are you gonna do number 3 and 4 also?
Yeah, we'll give some thought to that. I think we've got the issues at least, not necessarily the perfect resolution, but we'll take our hand at something.
Excellent. Okay. 3.
3 and 4 have screening. I think we should hand that over to Matt.
I would just say better than what?
Yes, I wonder if the word best would be better than better.
Right.
How to best utilize.
Could say leverage then.
So we'll adjust whatever we come up with at, you know, screening. 4.
What's the difference between utilizing and using? Other than extra letters?
Jack, you're our language guru. What do you think?
Well, I'd much rather be utilized than used, but I'm not exactly sure what the difference is there. I think it's a matter of people's stylistic preference.
Strunk and White would vote for using.
All right. Anything on 4 with the artificial intelligence and machine learning? Is this making anybody?
This is David Engstrom. This is David Engstrom. I guess I have a general comment about this section, which is that as I read it, I thought there was kind of an awkward or maybe a distracting tension between menu items in the list that take the form of something an agency should do, where it's pretty intuitive or where there's a pretty strong research basis for doing it. So menu items that do that on the one hand, and on the other, menu items where we're telling the agency that they should explore something in a more open-ended way. And so examples of the former would be, set up an ECM system, or use staff attorneys and clerks well, which seems really intuitive, or align your standard of review with your overall objectives. Examples of the latter would be clustering of appeals, which I think is controversial. It actually has been controversial at the line level at SSA, the clustering of appeals, for triage purposes. Decision templates, I think, are also a little controversial. And then I think the idea that agencies should use artificial intelligence, that's really open-ended. It even feels a little throwaway, and I feel like I have license to say that because, of course, I've drunk the Kool-Aid on use of AI by agencies more than most, and in fact, I'm one of the authors of one of the ACUS AI reports. So I guess what do we do with that? Like one possibility is you could implicitly order the items in this section to take account of that. So maybe try to put the ones that are more in the nature of what agencies should do, where it's pretty intuitive, or there's a strong research basis, and then end with the ones that feel a little more should consider or should experiment. You could also do it explicitly. You could divide this up into two chunks where we have a set of recommendations around appellate decision-making processes and decisions that are strong and intuitive and have that research basis, and then put in some of these more open-ended ones about using AI or what have you in a second separate section.
Thank you. Any thoughts about that?
I
So
agree
you'd
with
be
David.
talking about, oh, go ahead.
I think David's exactly right. And I think we better maybe with the AI, maybe the committee might want to think that we've got an AI project proceeding concurrently, and maybe we don't want to get out ahead of that project. So I think it's worth further thought.
It sounds like the distinction is a bit between things that all agencies should do and then some aspirational goals, like the artificial intelligence, that sort of thing, and whether or not we want to include both and how we break that out.
Yes, and I think every number here in this list begins with agencies should. So probably can draft it a little more efficiently.
No, I think, and David, you can speak to this. The point is that some of these things are, as Roxanne is saying as well, pretty obvious, and some feel a little more like exploratory. So I would put the AI one in that category. I guess I'd be curious to know what Judge Manuel thinks about that, but I can tell you it would make some people's lives at my agency, but go ahead.
Excuse me, I'm sorry, but I think the agency should consider having the robots wear a black robe. But we're having to kind of get used to that idea, the idea of just having sort of templates, if you will, and you kind of feed in the information and they come out with kind of a standard answer. And, could you really program it in such a way? Well, that's for another discussion, I'm sure.
Yeah.
But.
Well, that's why I think David's point is well taken, that maybe it's exploratory. Gavin, could we look at sorting these in a way that adjusts for that?
Which are the other recommendations that might be considered more exploratory, such as this one?
Can we go back up, scroll up? So the first one is whenever possible. And then the second one is where appropriate. I mean, are these, yeah, that's explore. That's great. So maybe we just reorder them. And then the question is whether, I think as David's suggesting, do they go in different categories? I think we could keep them as long as they're grouped together under the same heading. That might be okay.
If I could say that it seems that several of these numbered things specifically relate to screening. I'll forget that language, but the idea of screening cases and then feeding them in different directions. And the question is whether they could be all bundled into one number, because it seems like several of them are about screening and then others have nothing to do with screening.
I think Bill's giving Matt and Chris more work there.
We're happy to take the work, and I think there are a couple of these that actually Chris and I would like to give a little further thought to. Like one of them, for instance, is improving the overall quality of decisions. We've sort of gone back and forth about how specific and prescriptive to be there. We didn't want to criticize anybody, but that's one of the things on our list for discussion, in the next few days or further consideration.
I would just say also that to the extent that people are worried about screening being a loaded term, I wonder if the preamble, and I'm sure this may have been thought of, but whether the preamble forthcoming could be a useful tool for sort of defining or clarifying what we mean by screening in this context.
I think that so it would lay the groundwork for it. Yeah. That makes sense. Okay. So this is the language in 5 that we moved up, and we still have the de novo standard of review. This struck me as not very recommendation-like, and I wondered if anybody else had that reaction. Nope, just me.
No, I thought it stuck out like a sore thumb. You're an idiot if you do de novo standard of review.
I was just trying to figure out, yeah, I mean, I would take it out, that's me. But I welcome.
Are there many agencies that have de novo review for their appellate systems?
We do at our agency.
You do? Okay.
We're the idiots.
Well, you must have good reason for it.
Aren't some open record requirements statutory also?
I just didn't know, I mean, is the idea, and maybe Chris and Matt can speak to this, obviously we want agencies to establish a standard for review and then tell people what it is. Is the idea behind this that you want agencies to seriously consider not doing de novo review? I mean, that's the recommendation. It's we really don't think you should do this. Is that usually what we kind of phrase as a recommendation? Don't do this.
You generally avoid using de novo review.
But I don't understand. That's specifically what the APA provides. De novo review by the agency. And these appellate reviews are at the agency review. So I don't know why it's not advisable to have it. It's exactly what the APA provides. And are we talking de novo on facts, de novo on law? What are we talking about here? I mean, at least here, it's just, you're going to defer to the hearing, ALJ on facts and law?
Yeah, I'm curious what the origins of this, the impetus for this is. Because I'm with Bill on this in terms of the APA.
Chris, Matt, go ahead, Chris.
Yeah, I mean, so most, as the report kind of details, most agencies do not do de novo review of factual determinations. They defer to the. I mean, it's an appellate review system. They're trying to, it depends on the objectives that they have, but most of them aren't trying to make sure just do error correction. They're trying to identify kind of bigger issues and not redoing everything that the ALJ or the administrative judge has already done. I think USCIS is a really good example of this. They have a de novo review system, and they have a backlog of tens of thousands of cases because it takes so long to do it. So back in December of last year, they issued a notice saying they're going to change the procedural rules to review for abuse of discretion. And to only allow evidence in if there's cause and it's new. And I think that's something that a lot of agencies are struggling with. For instance, at HHS, You have a backlog of hundreds of thousands of cases that apparently will take 19 years to get through the backlog. And so one of the issues that we saw is that for an appellate system, as opposed to the agency head, and maybe that's an important distinction, but as an appellate system, if your objective is to not have a backlog of tens of thousands or hundreds of thousands of cases, you might want to rethink a trial de novo at an appellate level.
Well, maybe that's
And
very
Bill,
helpful.
I was just going to say to Bill that the APA doesn't prescribe de novo review, it allows de novo review. So if the agency head doesn't want to use de novo review, there's nothing wrong with that.
I agree completely, all right? But the idea is that, and I think what has been just said is that, you know, maybe what should be in here is not, it's a bad idea, but in considering whether or not to use de novo review, de novo fact review, one should consider the amount of time and resources it takes to do that additional type of review. I mean, to sort of give an explanation for why it might not be advisable in certain circumstances.
It's the volume issue. It's the purpose or objective of review could dictate that choice. I think this does. I agree that this should be much more nuanced. Again, we're happy to take a look at this and propose something that might work better in this context.
Can I just make a general suggestion about this?
Sure.
I would think that maybe a more positive statement. Agencies should establish a standard scope and standard of review, keeping the following factors in mind, and then list factors like caseload and timeliness and reliability of the initial decisions and such in a way that suggests that you only use de novo review if the factors that you would think about would indicate such. I think that would be a better way of placing this. It is sort of surprising to see something this clearly stated in an amicus recommendation. Maybe even mention the degree of deference, on the review should be attuned to, so that it's clear what we're talking about, rather than something like that.
Yeah, no, Chris, I thought that was really helpful. I mean, it just sounds to me like, for some agencies, that's just not a great idea. And so maybe the agency just needs to be taking into account their objectives and their caseload. And
I think it's fair to say, based on the interviews we did at the agency we looked at, which were focused primarily on high volume, that for most appellate systems, it is not advisable to have it in over standard review or scope of review. Maybe that's not the way it should read in an ACUS recommendation, but I think that's quite descriptive of the feedback we got from the agency officials in the case studies that we did.
I think that's fair. There's certainly APA systems where you don't have de novo standards of review, where agencies choose not to do it, in accordance with the APA's language. We can take a look at this further, though, and see if we can't propose something that might both be in accord with the research and satisfactory to the committee.
okay, that would be great. I think we're close to winding down here. So if there are any other comments on that might be helpful to Matt and Chris.
Natalie, do we have time to do the next one? I'd love to at least get feedback on the next one, if we could just get some, because that's one that Matt kind of suggested we're still stuck on and thinking through.
Number 6? Is it number 6, Chris? The next one?
That's right. Yep. Number 6.
I had a reaction to this, which was just it should be written to encourage agencies to issue high quality, readable, and plain language decisions without this implication when you say improved, or right now they're low quality. That was basically my overall reaction to it.
My feeling is agencies should strive to improve everything they do. So
I wouldn't use increase. Again, increase is no different to me than improve in this context. That agencies should
Strive to
Agencies
provide.
should make their decisions readable.
Strive. Yeah.
Make their decisions readable.
Strive for readable and quality appellate decisions. And it's opinions too, isn't it? Is it decisions or opinions?
Opinions. And yeah.
If we're going to end in 4 minutes, I think we need more time.
Yeah, I mean, I'll just say, you know, I can only speak from my own experience. This is something that we strive for all the time, and a lot of things are out of our hands, career employees, when you have political appointees who come in and decide appeals and have things, want to say things a certain way or do things a certain way. And so we do the best we can to adapt that, and hopefully it's readable. It's got to be readable for the parties. It's got to be readable for the public. And then you want it to hold up on appeal, and you want an appellate court to read it and say, this makes sense. This isn't.
And you also don't want an appellate. I mean, this is where I think Chris and I want to give a little more thought to this one. This is an area where some appellate courts have been pretty critical of agencies for one practice or another. Overuse of boilerplate, excessively long opinions, insufficiently long opinions, incorporating by reference huge portions of ALJ's decisions with footnotes, like an annotated a commentary on the ALJ's opinion. So there are a lot of practices out there that have come under criticism from especially the appellate courts, and I think we were struggling with this a little bit. Maybe we could give it a little bit more thought before the next meeting.
Yeah, and if any of you have thoughts offline on this, I mean, let us know. Matt's not going to let me include my ranking of the different agency appellate opinion. I have my own, and he won't let me run it through that Ross whatever, like, you know, opinion scorer, you know, the online program where it'll actually give you a score out of 100 on how well it's written. But
well, Chris, I actually thought maybe that could be a recommendation.
The Ross, is it Ross Gruber? I can't remember.
Yeah, the Ross Gruber.
Yeah,
Can I make a quick
thought
comment?
I thought it was a pretty good list that Matt just gave in terms of specific ways in which to improve the opinions. I think that would be well received by judges. And judges would also probably say that you also have to take into consideration the resources, how big their docket is, and all these considerations about time and things like that. But those specific points about improving opinions, I think would be well received.
Gavin, could you also just add on that list something about so they can be judicially reviewed? That's something we hadn't focused on, Matt, that we should add. That's another kind of objective there.
Yeah, and you don't want, like, I mean, the reception that these things get on, I've actually, not in connection with this project, but talked to a number of judges federal judges about this issue, is some of them wince when they see agency decisions, and it kind of turns them off. I mean, the only one who's sort of, not the only one, the one who tends to express that bluntly in writings is like Richard Posner, complaining about boilerplate, and he's taken shots at the NLRB, for instance. I don't mean to do that myself. But you do hear from federal judges sometimes that they're kind of turned off by the way opinions read for one reason or another. David Marcus and Jonah Gelbach pick up that theme a little bit in the report they did for ACUS on Social Security appeals, but it may be something for us to give a little more thought to, and how to do this in a diplomatic and constructive way.
I think that would be great. Go ahead, Jeff, you had a point?
So yeah, I just wanted to go to number 7 real quickly and just add a word there, which would be selecting and publishing precedential opinions. And then I had a question for our experts. Can we say anything about the practice of secretarial own motion review of appellate bodies? The AG, BIA, DOL, the DOL board. It seems like there's a lot of controversy over that now. Can we say that when an agency has set up one of these boards to to review most of these, you know, lower level cases, that the secretary should, you know, not interfere too much, or is that just impossible to?
I mean, Matt can jump in. My reaction is that it really exceeds the findings of the report. I mean, obviously we talked about this with the agencies that have that, but we really did collect findings that I think could meaningfully weigh in on how the AG should exercise, you know, her.
Not just the AG. I don't want to make it just AG, but generally speaking.
I mean, I mean, the committee can always do stuff that isn't supported by the report. I feel like probably would be outside of the report. Maybe Matt disagrees, but.
I agree with you. I'm also sort of thinking, now I'm taking my researcher hat off and I'm thinking about this one at the plenary session. Wow, this is a big issue.
Yeah, I'm going to agree with you on that.
We
All
actually
right,
already touched this in one of the earlier discussions of sua sponte taking cases up. So it's already in there because, you know, when the Attorney General, for example, takes an immigration case, that's an example of sua sponte taking a case up.
Yeah, you'll see. I mean, we talk about it in the report a little, and there's a sentence in there that talks about how immigration scholars and lawyers have voiced concerns about it, but that's basically where we stop.
Yeah.
Okay, we're after 5. Very productive today. All the input, great input. And I know there's more work for Matt and Chris, but we're on the tail end, Gavin, I think. Thank you for scrolling down so we can see how much we have left. And then we will have the preamble next time to work through, but it will be short and sweet and concise and perfectly written.
If we have any comments on the remaining part of the recommendation, should we just send them to Gavin?
I think that would be helpful.
That sounds good to me.
So we can get things in shape for the next meeting, which is Monday, the 23rd, right, Gavin? I have that right?
Correct.
Yeah. And I look forward to seeing you all then. Hopefully you can make it and we will wrap this one up. Thank you so much. Have a great weekend.
Thank you.
Thank you.
You too. You too.
Thank you, Nadine, everybody.
Bye.